initiative done by the Rotaract Club of NSBM together with the Rotaract Club of CFPS Law School and the Rotaract Club of University of Colombo Law Faculty. As you may already know, this session will focus on the law essentials that someone who starts a business would want to know. This is not a question which can be answered very simply from a Google search, for instance. And that's why we felt it was essential that aspiring entrepreneurs in particular should know what they should take into account when starting a business. And in order to do that, we have a panel of distinguished individuals who are all attorneys at law. To go a bit further, we have Mr. Boopathy Kahathuduwa, who holds a Bachelor of Arts in International Studies from the University of Colombo. He is a CIMA pass finalist and is a member of the Bar Council of the Bar Association of Sri Lanka. We have Ms. Indra Punchihewa, who holds a Bachelor of Laws from the University of London and a Bachelor of Science in Medical Entomology from the University of Peradeniya. We have Mr. N.K. Ashokbharan, who holds a Master in Law from the University of Edinburgh and is a Chevening scholar and a holder of the Bachelor of Laws from the University of Northumbria. We have Ms. Thevuni Amaradasa, who holds a Bachelor of Laws from the University of London and a Master in Laws from Monash University. To all of our distinguished panelists, thank you so much for joining us today and taking the time out of your busy schedules. We really do appreciate it. Before we start, on behalf of all the Rotaract clubs, I would like to apologize in advance if there are any unforeseen technical difficulties. Understanding that this is also an online platform, we kindly request all panelists to have their web cameras on at all times, and also for the participants who are joining us via Zoom to be mindful in the sense that you don't accidentally unmute yourself or won't accidentally switch on your web cameras. But also do feel free to answer any and all questions by writing in the chat box. We will try to answer everything as much as we possibly can in the limited time period towards the end of our session. On that note, I would like to invite Mr. Boopathy Kahathuduwa to start off today's session. He will touch on the subject of forming a startup, through which the questions of how and when compliance becomes important will be answered.
Right. Thank you, Navira. Right. So you have decided to do a startup. So maybe you have got a great idea. Maybe you have got together with your friends, right? Maybe it might be a tech startup. It's very, very common days to start a tech startup. Or it might not be related to technology. Maybe you want to do an export business, right? Not really a startup, but a traditional type of a business. And now you are wondering whether you should speak to a lawyer, right? Now, the first question that you might want to ask yourself is, am I ready to run a business, or am I doing a project? Now, often we see, especially now, I think the community that we are looking at here, who have joined our program either through Zoom or via YouTube, is the community of students and who are mainly into tech startups. And often we get people coming to us and asking us questions on should we incorporate a company. Now, the first question that you need to ask yourself, is this a project? Right? Maybe you might be able to work on this idea without incorporating a company in the first place, because most of the ideas, sadly, they die quickly, right? And most of the startups, unfortunately, this is factually, statistically, this is what is said by research. Most of the startups, they fail. And you're working on an idea, right? It's great to work on an idea, but say that you start by incorporating a company, and after 3 months, now you realize there is no product market fit, right? You realize that you are not getting any real customers. You realize finally that it was just a project that you guys were interested in, but now nobody is interested in the company at all, right? You're 3 months down the line, 4 months down the line, maybe 6 months down the line. Now you have a team that's not interested in the idea anymore, but the company is still there, right? You can't just shut down a company. And there is a particular process. I think the next speaker is more competent than me to speak about that. So there is a particular process that you need to follow. And if you incorporate a company, there are returns that you need to file, right? I mean, even if you don't have to pay taxes, if you don't make money, you still have to file your return, right? And say that you didn't make money. So there are lots of legal compliances that you need to follow up. So the first question that you need to ask yourself, do I need that? Maybe the answer is, no, I don't need that, right? I'm working on a project. We have an idea. We just want to work on it and see, right? But if, of course, if the idea that you are working on, right, requires an incorporation of a company, if it requires for you to, I mean, it doesn't have to be necessarily a company per se, it can be a partnership, it can be a sole trader. But of course, if you're starting an entity, it's always recommended to go for a company, but depending on the situation, you might want to go for a different form also. Now, certain types of businesses may require you to incorporate a company. Now, for example, if you want to get a payment gateway, the payment gateway might require you to either have a company or a partnership or a sole trader, right? You need some type of a business registration, and you need to submit that business registration certificate to the bank to get that payment gateway. So your idea won't proceed unless you have an entity, some type of an entity in place. So again, you need to decide, what am I working on, right? And does this project or does this idea requires an entity? If so, then yes, you need to get yourself some type of an entity. I think Ranindra will be speaking about this a little bit in length, explaining different types of. You do decide that you require an incorporation, right? If you do decide to go for a company, I think it's always advisable to go for a company if that is required, because investors will prefer that type of an entity, and also you will have a record of all the transactions, especially at a later stage when you want to do a valuation of the company, right? If you don't have a proper record of investments that you have put in, right, the capital that you have put in, it becomes very difficult at a later stage to really evaluate and give a proper valuation to the business. So it is advisable to get yourself a company incorporated if it is required, and always make sure that you have a proper record of transactions. I will share with, I think, with Navira a link to one of my Medium articles on teaming agreements, which is something that you can do without getting a company incorporated. If it's a project, maybe you might be able to enter into some sort of a teaming agreement where you agree among the co-founders, this is my responsibility, these are my duties, and on a day that the company is incorporated, this is how the shares will be, this will be the share split among the co-founders and all of that. You might be able to put it into a contract and sign a contract. So on a later stage, when your entity is ready, you can get it incorporated. So I'll send it to Navira, you can check it out later. I think, Navira, that is what I wanted to say about the question. I'll take up the questions and all when the time is right.
Okay, sir. Sure. So since the Q&A is the end, would you rather wait till the end, or do you want to go ahead and answer them now?
If anybody has a question, I can take it right now, or I can wait till the end. There was some questions, I think, which was posted to us on the registration. If that's all right, I can take it right now.
Sure, sir. No problem from my end.
Right. So I think I have already answered this question, the legal proceeding to start up registration and why registration is much needed. So the answer to that is what I have given. If you believe that compliance is required, then you should go for registration. If you are going to go for registration, there are different entities which are available. One type is companies, then there are various other types. I think the next speaker is going to speak about that. Right, so if you then about registration and funding for startups. So if you are planning to raise funding, now there are different stages of funding, right? We call them seed round, then Series A, Series B. Likewise, if you look at the international standards on funding, there are different rounds of funding. So if you are very serious about it, right? You have an investor who is ready to invest in your company, then I think the best is to get a company incorporated and to proceed with that. I'll take the questions on the Q&A session if anybody has any other question.
Thank you, sir. Next, I would like to invite Ms. Indra Punchihewa, who will be speaking on the legal aspects that is necessary when incorporating a company in Sri Lanka.
Hello everyone, wishing all of you a very good evening. I am Indra Punchihewa. So basically I will be talking about registration of a business and incorporating a company in Sri Lanka. I have a presentation pre-prepared for you all, so I will share my screen with you all so that you can see, because this topic is very large and very extensive, and there's very much a lot to discuss in this topic. It actually cannot be limited to 15 minutes. So I have limited my talk to 15 minutes, but then most of the material which will be valuable for you all are available in this presentation. I think the admin has to allow me to share my screen.
Go ahead, miss.
Okay. Yes, so this is my presentation, and Mr. Boopathy used to explain actually how and why actually we need to register our businesses and register our companies and give it kind of a legal recognition. I think some issues. Okay. I will be discussing the types of businesses actually prevailing in Sri Lanka according to our law. There are sole proprietorships, there are partnerships, which is also known as joint ventures, and there are private limited companies, public limited companies, unlimited companies, companies limited by guarantee, overseas companies, and offshore companies. So basically, these are twofold when it comes to registration. Why I'm telling that these are twofold, sole proprietorships and partnerships, we have to register those businesses at the divisional secretariat of the respective area of at where you are going to initiate your business. And the other companies, other types of companies, you will have to register them with the Registrar of Companies according to the laws available in the Companies Act in our country. So, explaining how we should make the registration of sole proprietorships and partnerships at the Divisional Secretariat, I will explain. So, the sole proprietorships, any citizen of our country, Sri Lankan, can apply. Even though that person may hold a dual citizenship with another country, it doesn't matter, as long as that person is a citizen of this country as well. So first, that person has to meet the relevant officers at the Divisional Secretariat and collect the relevant form. So the relevant form, according to the law that we have to fill in, is Form R1. And when you explain the nature of the business and that you are going to be putting your own money into the business and only you will be controlling the business, and the Divisional Secretariat will suggest that you are going to be a sole proprietor of this business, property holder of this business, so you may fill in this R1 application. And then you will also have to discuss the nature of the business, whether it's import and export. There are various types of businesses now with the technology, the advent of the technology as well. So import and export, whether it's a production and what type of a good that you're going to produce, or what kind of a good that you're going to import, export, whether it's hospitality, pharmaceutical, food and beverage, Ayurvedic treatments, and we can name a list. It is endless, the types of businesses with the innovations coming up in our country with the new brains. So you can discuss the nature of the business. Why you need to actually discuss the nature of business with these officials is, depending on the nature of the business that you are going to conduct, you will have to comply with different other regulations and laws existing in our country. For an example, if it is a pharmaceutical business, then you will have to comply with the regulations, with the health regulations in our country, and you will have to get a license from the logistics, health services and logistics department in our country. And for food and beverages, you will have to get a recommendation and a license from the PHI of that respective area. And for medical treatments, the doctors have to register themselves, and the pharmacists, doctors, they are obliged to register themselves with the Sri Lanka Medical Councils, and they have to display their certification. So likewise, and for Ayurvedic treatments, according to the Ayurvedic Act, the places have to be registered with the Ayurvedic Medical Council. And for personal care, such as beauty services, the spas, and those kind of businesses, then they have to get the license from the health, the PHIs, and also they have to display their relevant certificates, their qualifications in their business premises as well, and they have to produce, even in registering. When registering your business, when in the attempt of registering your business, they have to produce those certificates of qualifications also. And so they are always, this is the registration of business in a country. Why it is very important is, adding on to what Mr. Boopathy has said, it is actually very important. Anything, legalizing, registering anything in a country is important in terms of regulating and keeping up to standards in a country. So that is why these processes are here. So you have to provide all this licensing and recommendations. And food and beverages, you have to get the license of the PHI. Even meat shop, poultry shop, anything. So you have to collect those relevant recommendations and licenses. And then you have to obtain the report of the Grama Niladhari office of the area where you are going to conduct your business, and then sign the same and get a counter signature of the same by the Divisional secretary of the relevant area. So these are the steps that you have to comply. And the relevant document, the usual ones, the national identity card and the road map showing the route to your business premises, and also the deed of the business premises. Now, if the business premises original owner is the person who is going to apply for the registration, then fine, the original deed can be produced. But if you're having the premises under a lease, then the deed of lease you will have to produce. And if you have mortgaged the property to a bank, then you have to apply for a certified copy of your deed from the bank itself. And if the premises is taken only by the consent of the owner, if I give you an example, let's say you are going to initiate a business in a property of your parents. So then you only have the permission of your parents. Then what you will have to produce is a document which supports the consent of your parents and stating that they don't have any objection of you conducting a business in that premises and their national identity card and so and so. And also the Gram Niladhari has to issue a letter confirming the address of the business premises. And partnerships also, just as I said, you have to go to the divisional secretariat. The types of documents are very similar to as of a sole proprietorship, but the only difference is here you will have to submit the partnership deed or the partnership agreement. So according to partnership law in our country, if the investment is more than 1,000 rupees, which is the case for all the partnerships, I hope in this country after the legislations have been made, you will have to now submit a partnership agreement or a partnership deed, as of the colloquial language, to the divisional secretariat, and all the other relevant documents will be same as to the documents which one has to submit for to register a sole proprietorship business. And here the form will be R2, but there the form was R1. So you have to remember that in your mind. And moving on from sole proprietorships and partnerships to a company, there are actually various difference of companies, as you have seen in that chart. So there are different small differences when it comes to registering incorporating a company in Sri Lanka. So first, in this process, what you will have to do is you will have to reserve a name for your company according to Section 7 of the Companies Act. And so you will have to reserve a name in the sense it should be a name which no other company in Sri Lanka is having. And there are also other regulations pertaining to names and restricted words pertaining to names. So by complying to those regulations which are put out in the Section 7 of the Companies Act, you will have to reserve a name with the Registrar of Companies. And that can be done very easily through the Registrar of Companies website. That is through eroc.drc.gov.lk. And it is a self registration process, I call it, because now, unlike in other past days, now you can, if you wish to initiate a business, you yourself, without the help of a company secretary, actually can make these entries and initiate your own registration. Now you all are law students, most of you all are law students, I guess, so it's better to keep up, try this as a part of your learning process, so that in the coming years, if you move into company secretarial practices, then this will be very handy. So then after updating the information, you will have to upload the relevant forms and make payments online and collect the incorporation documents. So what are these documents actually? Now we'll have to prepare to register our company, to incorporate our company, I would rather say. So the documents which are relevant to incorporate a company is first an application form signed by each of the initial shareholders. Now, who are initial shareholders? Initial shareholders are people who are contemplating to be the shareholders of this particular company that they are going to incorporate, and who have contributed money into a percentage of shares in a company. And they all have to sign the application form to incorporate a company. And then a declaration to the best of such person's knowledge that the name of the company is not identical or similar to that of an existing company. Now, just because now the process is online through the Registrar of Companies website, this declaration actually you don't have to prepare it by yourself. When you initiate the process to reserve your name, after about few days, they are government officers, they take some time to check whether your name is not similar to some other company's name. So they'll take some time and they'll come to you with the result as if it is not similar, then by confirming your name. So this declaration now you don't have to prepare it by yourself. In the automated system, they are doing the approval and they are sending it to you through your EROC account that you will have, you are going to make. And then what you will have to submit is articles of association. Now in this case, in the Schedule 1 of the Companies Act, they have given a model articles of association. So companies are at their independency to use it or not. So it is very advisable to go with the model articles of association because that have covered up all the aspects a company in Sri Lanka has to cover up. So there can be some situations that you will want to deviate from those model articles, and you have the liberty to do that as well by amending, incorporating new sections, or amending the existing sections of the model article. So by actually adding new articles as well. So you have that liberty. So it is very advisable to use the model articles as a structure and then go on with the drafting of your own articles of association according to the business plan of your business plan. So then there's two forms which are very important in this incorporation process. We actually, in the normal legal language, in the company secretarial practice, we call them as Form 18 and Form 19. So Form 18 is where which you are going to obtain the consent from each of the initial directors of the company. So the people who are willing to become the directors of the company, they have to provide their own consent. They can't be appointed forcibly. They have to provide their own consent, and this step is very crucial in incorporating a company. So they'll have to provide through Form 18 their consent that they are consented to become the directors of this respective company. And also in Sri Lanka, it is a must to have a company secretary. A company secretary can be a lawyer who holds the company secretary qualification, or a chartered accountant is also able to become a company secretary in Sri Lanka according to the laws, the company law given in our country. So the consent from the initial secretary is also very much relevant. That is that consent is conveyed via the Form 19 according to the company law in our country. So these are the documents that you will have to submit to incorporate a company. So this is very simple. This is not rocket science, a very simple process. So if you start learning and developing your skills on these documents, then you will actually have good practice to build up a company secretarial practice as well, apart from having your own business. So this is a model of an incorporation certificate that you will be receiving from the registrar of companies after fulfilling your all the requirements to incorporate a company in Sri Lanka. Is my time over or not? Because this lot. Navira, can I talk more?
Miss? Yes, miss. Yes, ma'am, you can go ahead.
Okay, thank you very much. So then there's company limited by guarantee, because as I told, I can talk forever about this topic because this is this much interesting and it has so much information. And company limited by guarantee, if I say, these are companies which does not issue shares actually. They have a different set of objectives, mostly charitable objectives, or promoting science, education, and those kind of objectives, not actually the profit-oriented objectives they carry. And they, the people in this country who invest in money, they are not called as directors. They are like more towards, they are called as guarantors, because at a situation which they are going to wind up, or let's say if they are going to get liquidated, those guarantors have agreed in their articles to an amount that they are going to put in such a situation. So but for the sake of law, we call the people, the members, as directors. And then there is also a company secretary, as in usual companies, private limited companies and public limited companies, as we discussed earlier. So here also the registration process is very much similar to the company, the private limited company and public limited companies. But however, under section 34, now we have to submit in these articles of association the private limited companies and public limited companies. According to our law, it is not obligatory to put the objective of the business. But in company limited by guarantee, we actually have to put the objective of our business, the objective of our company, because the registrar is going to see and make himself satisfied whether this company limited by guarantee is going to promote and promote science, religion, charity, sport. As I said, are they actually involved in non-profit oriented work? So for that case, you have to actually put in the objectives of, if you are going to incorporate this kind of a company, you have to put in the objectives that you are going to achieve, you're planning to achieve in this business. So if the registrar is satisfied only, then that particular company will get the incorporation certificate as a company limited by guarantee. And also, there are two more interesting companies in Sri Lanka, which are offshore companies and overseas company. So if we talk about offshore companies, these can be companies incorporated in another country or in this country as well. But after incorporating themselves in our country as offshore companies, they only can do business, but not in our country, but out of in the jurisdictions out of this particular company. So they are carrying on businesses offshores of this country. That's why we call them as offshore companies. They are engaging in offshoring business processes. They are doing business outside of our country. However, this is not an incorporating a company in Sri Lanka per se, because this is like re-registering a company which is already existing in another jurisdiction or in Sri Lanka. While looking forward to some fiscal concessions, tax concessions, and customs concessions, with a view of something like that. But however, it is questionable whether our country is providing the most for offshore companies when comparing to other companies who are providing offshore company opportunities such as Cayman Islands and especially Singapore. So even to incorporate an offshore company, they have to, just like in our country, they have to submit a certified copy of the articles of association of the company or an instrument which is identified as similar to articles of association according to the country which they have been incorporated already. And also a list of directors of those managing the affairs of the companies will have to submit, and person or persons who are resident in and are citizens of Sri Lanka authorized to represent that particular company within our country, and also the registered address of the company in the country of incorporation. So let's say if this company who is going to re-register themselves as an offshore company is a Sri Lankan company, so we have to provide that particular address. If that is a company from UK, they have to provide that particular address. And also the certified copy. In the act it says certified of recent date of incorporation of the company, but I think it is a typographical error. I think it's the certified copy of the incorporation certificate of that particular company which they are actually requiring, because I have been part of one of the process of registering an offshore company. So for this, a question of course arose regarding this statement. So instead of recent date, what we submitted was a certified copy of the incorporation certificate of the of that particular company. And also, now in most of the European countries, they have their own national languages, and they have documents in their own European language which is native to their country. So in such a situation, when we are re-registering a company in Sri Lanka as an offshore company, then their documents, if they are in their native language, we'll have to translate them into the official language which we are using to incorporate companies and do company work in Sri Lanka, which is English, and we'll have to translate those and submit. So then, by providing these documents, we may initiate the incorporation process of an offshore company in our country. And also, there was a question which was sent to us from the applications, whether our country, is it a must to have a, no, I think whether we can't have a company incorporated in Sri Lanka where all the shareholders are foreign shareholders. Well, that is not the case. We can incorporate and register companies in our country with all the shareholders being foreign. But as you see, the requirement is there should be a person. We actually, in our day-to-day work, we identify this particular person as a nominee director. We actually have to have a nominee director who is a resident and a citizen of our country to represent that particular company in Sri Lanka. But that company itself can be consisting of 100% foreign shareholders and 100% foreign directors. I think I cleared that question for you all.
Yes, ma'am. Ma'am, I'm so sorry to cut your
Yeah,
presentation
that's
short.
why. I might get questions from these areas during the question and answer period. So I will answer any of the questions that the students are going to ask from me. Thank you very much.
Thank you so much for that in-depth presentation, ma'am. I'm so sad that I can't listen to everything and complete
Yes,
it.
yes,
It was
yes.
so
No,
interesting.
no, I understand. I can talk forever. That's why I told in the very beginning. It's all right.
Thank you so much, ma'am. Next up, we have Mr. Ashokbharan, who will speak on hiring for a startup.
Good evening, everyone. It's a pleasure to talk to you on a lovely December evening. Although this time the season is a bit dull, I should say, without any celebrations, which had enabled me to join you on a Sunday evening at the comfort of my home. So most of us, when we talk about startup, the whole word of startup and this startup culture, we look up to the United States, because that is where all these tech startups came. I think the whole nomenclature of startup is inspired by United States IT sector. That's basically the Silicon Valley. But there is a fundamental difference which we have to appreciate between the United States and Sri Lanka is when it comes to the employment laws. I do not know whether most of you were old enough to watch Donald Trump's The Apprentice show, in which he had this famous line, "You're fired." So he comes on and he hires people. He's not satisfied. He says, "You're fired. You're fired. You're fired." So somehow, inspired by all these United States things, naturally, that's a quality of being Sri Lankan, I believe. We tend to have an idea at the back of our heads that we start a business, we could hire and fire. Unfortunately, that's not the case when it comes to our labor law. I have had clients who come to me and even ask, what if we say in our contract we can fire whenever we want? Well, you can have all the absurd clauses you want in the contract, however, the law of the land shall always prevail. So, I believe that one of the biggest pitfalls for the startup culture in Sri Lanka is not appreciating the legal system and the laws and the framework in the country. So let me make a brief overview of the employment law structure in our country, give some introductions here and there, which I believe will be necessary to appreciate when you're starting a startup, and then I will get into specifics. I think I have a couple of questions already given to me, and I will address those. So when we say employment, right, in Sri Lanka, we can appreciate few different kinds of employment. One is the permanent employment. So when you are recruited by a company or an institution which says employment contract, then you expect to be with that institution forever until your retirement, where the contract says a retirement age. So on retirement point, let me touch this. Sri Lanka does not by law has a retirement age, but in practice for private companies it's 55, and which is always considered out of practice as the retirement age. So when a company offers you an employment on permanent basis, or what we say regular employment, it's presumed that you will be employed until you retire. The other, of course, is where we say fixed term contracts, where an employment contract is given to you for 1 year or 2 year or 3 or whatever the fixed term period that is, and the understanding is at the end of that term the employment ends. And of course, beyond this, we have traineeship contracts, and of course casual employment. Casual employment, of course, when to call an employment casual employment, there are certain ingredients which you have to take into consideration. One, it must be casual in nature, and it should not be part of the core business of the employer. and it could be a very short-term employment. So these are the broad areas of employments. I don't want to go into detail into an academic analysis of them. So the question here for most startups is, should we hire permanent employees or should we hire on contract basis? Well, some smart startup owners have asked me, why can't we then give 1 year fixed term contracts and keep on renewing it? Of course, they are smart, but unfortunately, our legal system is smarter than them. So where you consistently renew a fixed term contract, there are several authorities which has established that will become a permanent employment. So giving a fixed term contract of employment and keeping on renewing it is not a way to circumvent of making an easier way to sack your employee when you want to do that. So you have to appreciate that fact as well. However, one of the very interesting questions I received from the registrants is that, what if an employee is not performing? The performance is not satisfactory. Of course, the termination part I will cover at the latter part of my talk, but all employment contracts can have a probationary period in them. So when you say probationary period, the law sees that as a testing period, a trial period, where you are testing out an employee, where you're seeing whether this employee is apt for your company, for that role. So you can always test out an employee for 3 months or 6 months, whatever the probation period, reasonable probation period you decide on. And within that period, for bona fide reasons, pardon my Latin, that is a bad habit when you're a lawyer, especially when you are doing trial. So bona fide means with good intentions. For good reasons, if you find that employee to be incapable, or you're dissatisfied with the performance during the probationary period, then you can terminate the probation, right? At that point, the probationer can go and challenge that termination, but then the onus, the burden is on the probationer to prove that his termination was not done with bona fide intentions, that is, good intentions. So as a startup, you have to be very careful when you are hiring employees. And of course, when it comes to minimum wage, I do not believe that is going to be an issue, because our National Minimum Wage Act of 2016 clearly prescribes that rupees 10,000 a month or rupees 400 a day for day wages would be the minimum wages. And in addition, if your particular industry, you have to check whether your particular industry falls under any of the established wages boards. In that instance, you have to follow the conditions set out by the wages board as well. So tobacco, banking, and there are 40, if I'm not mistaken, there are 43 or 44 wages boards established as of now. So you have to check on that, and that is the minimum wage requirement. And I do not think, as a startup, you would be intending to pay less than 10,000 rupees a month for an employee, or I don't think you will be able to actually recruit someone to come and work for that amount of money. So this is another thing you have to always keep in mind. Then the biggest pitfall. It's not just about hiring an employee and paying the employee's salary. Even when you are planning, now I know, I've worked with startups, so I know how your budgetary system works. Your budgetary system is, you have a particular amount for a year per head. So that is, per overhead, you have a budgetary amount. Do not divide that by 12 and allocate the salary and decide on the salary. Always beware, there is something called mandatory statutory payments, the EPF and the ETF. EPF comes up to 20%, that is, you have to deduct 8% from the monthly salary of the employee, and the employer should contribute 12% of the monthly earnings, not salary, earnings of the employee. And ETF, the employer has to contribute 3%. So employer in total every month has to contribute 15% of the employee's salary earnings. And why I say earnings is it's not just the basic salary, it includes permanent allowances, etc., etc., not the overtime payments though. So you have to be very careful when you are budgeting an employee's salary. You have to give provision for EPF and ETF. And remember, non-payment of EPF and ETF is a punishable offense. The directors of the company, if it's a company, or if it's a sole proprietorship or partnership, then the sole proprietor or partners are personally liable. So you can't come and play the limited liability card of the company saying it's the company who's the employer, not the directors. So you have to always keep in mind it's a serious issue. You can be prosecuted, and that is a punishable offense. And of course, working hours is the other thing. When it comes to startup, you think we'll have unlimited working hours. Of course, at the start, when everyone is passionate, it's fine. They're putting in a lot of effort. But you have to always keep in mind certain regulations, especially Shop and Office Employees Act, how it defines working hours. So it says 9 hours per day, including 1 hour. So the employment cannot be more than 9 hours per day, including 1 hour break, and it cannot exceed 45 hours a week. So you have to always keep that in mind. And definitely every week, 1.5 days holiday, and for working on holidays or overtime, the salary must be paid by 1.5 times. That's 1.5 times of salary must be paid. So you have to always keep in this mind. But this working hour restriction does not apply to managerial level, executive level officers. So if you are recruiting only executive level officers for your shop and office, then they can work the amount of time that is necessary for them. So that is one advantage I believe modern companies might have in recruiting more and more executives. Said that, you also have to keep in mind about the annual and casual leave. Under Shop and Offices Office Employees Act, the annual leave is 14 days paid leave, and casual leave for medical reasons everything is 7 days paid leave, is all mandatory. Another thing when it comes to holidays, I believe all startups should keep in mind is the maternity leave. Under Shop and Office Employees Act, the maternity leave would be 84 days, provided that after the confinement, the confinement results in a live child. If the confinement does not result in a live child, it would be 42 days maternity leave. And for all other employees who are not even covered by the Shop and Office Employees Act, the maternity benefit ordinance applies. Again, that too is 84 days in total, but 14 days prior to the confinement, and after the confinement 70 days if there is a live birth, and if there is no live birth, 28 days. So maternity leave is something you have to keep in mind, and you cannot dismiss an employee on the ground that the employee is seeking maternity benefits. And unfortunately, despite all equality we talk about, Sri Lanka does not give paternity leave, which is a sad state of affairs. Maybe I believe our good friend Boopathy would be able to become an activist and change that sometime. And now to the important topic of Donald Trump's favorite topic of firing, termination. You can terminate an employee on the grounds of misconduct. So when you say misconduct, there is no exhaustive list. Theft, sexual harassment, you name it, coming to work, drinking at work, you name it, the misconduct. There is no exhaustive list of misconduct. And it is important to appreciate that our law does not require the employer to have a domestic inquiry. That is, to call for explanation, have an inquiry, and then decide whether to dismiss or not. However, our law requires that a termination cannot be unfair and unjust. So when a termination is unfair and unjust, our laws give the employee several options, including complaining to the Commissioner General of Labour, where the Commissioner General can again refer to arbitration or mediation, or of course go to the Labour Tribunal or claim damages under the normal law in the district court. So an employee has wide range of remedies available at his or her disposal. In this context, labor tribunals are very important because they have wide powers. Of evidence ordinance, they have the right to look into and inquire into everything the president of the labor tribunal thinks is necessary, and of course, they can give a just and equitable order. They can give a just and equitable order. So which means they can also reinstate. Now you go to the district court claiming damages, you can only claim damages, compensation. But you cannot, the district court does not have the power to reinstate an employee. But the labor tribunal has that power to reinstate an employee. So the reason why an employer, or the motivation for an employer to have a domestic inquiry, call for explanation, ask the employee to show cause, give a fair hearing, and then decide on the dismissal is that then at the labor tribunal, if the employee goes to a labor tribunal or challenges the termination, that saying that this termination is unjust and unfair, the employer can show his bona fides, that is his good intentions. He can show that he has acted with in a just and fair manner by asking the employee to show cause, then issuing a charge sheet, hearing the employee's side, and then deciding. So that is the role of disciplinary hearing or domestic inquiries in Sri Lanka. It's not mandated by any law as such. So this is where you dismiss based on disciplinary grounds for misconduct. But the other question is, can an employee be dismissed on non-disciplinary grounds? Say redundancy, right? Say redundancy. Well, then the provisions of TEVA, what we say in a colloquial term is TEVA, that is Termination of Employment of Workmen's Act, Special Provisions Act. Under TEVA, there are two conditions. You can dismiss an employee on for non-disciplinary grounds on two grounds. One, with the consent of the employee, or two, with the consent of the Commissioner General of Labour. Now, so the best way as lawyers we advise the clients who want to terminate an employee on non-disciplinary grounds is to reach an agreement with the employee. Because even if you seek the permission of the Commissioner General of Labour, and Commissioner General of Labour gives you permission, there is a certain formula, gazetted formula, the Commissioner General uses to calculate the amount of compensation, which is capped at 1.25 million. So you can negotiate with the employee and you can come to a settlement, and you can obtain the consent of the employee, or in other words, the resignation from the employee, and for whatever the settlement you have reached. So that is the recommended ground of termination. And coming back to the question, you have said whether when an employee does not perform well, what can we do? Can we sack? Yes. Non-performance, or in other words, what we say, inefficiency, incompetence, or unsatisfactory discharge of duties are also justifiable and valid grounds for dismissal. So you can always seek on that ground, but you have to keep in mind that it's always better to reach a negotiated settlement with the employee when it comes to termination. I'm open to take questions, so if you have any questions, please feel free to ask, or even in the chat box, and I'll be happy to answer. Thank you everyone for the opportunity, and I'm looking forward to the other speakers' interesting comments.
Thank you so much, sir. This is also a reminder for all the participants that you are free to question any of the panelists by by typing it in the chat box. Unfortunately, because we have very limited time constraints, we won't be able to entertain all questions. So it's best if you can start putting your questions now itself. Last up, we have Miss Amaradasa, who will be talking about the issue of trademarks.
Yes, thank you, Navira. First of all, I'd like to thank the Rotaract clubs of CFPS, NSBM, and the law faculty of Colombo for inviting me and having me here. My topic is about trademarks. Why should startups consider registering their trademarks? So the importance of registering them at a very early stage. When you're thinking of a startup, when you are actually brainstorming and coming up with an idea, you probably wouldn't want to think of registering your trademark. First of all, you want to probably register your company and come up with, develop your product and so on. But it is very important for even startups to come up with a really, really good trademark and register it under Sri Lanka intellectual property law. So we have the Intellectual Property Act, number 36 of 2003. We call it the IP Act. You can register your trademark, but remember, registration of trademarks is not compulsory in Sri Lanka. If you want, you can register it. And if you do register, there are so many benefits of doing so. So before actually talking about the importance of trademarks, I'd like to define what a trademark is. So as per IP Act, trademark is any visible sign. So in Sri Lanka, only visible signs that serve to distinguish goods and services of one enterprise from another enterprise. So basically, any mark that enables the consumer to sort of identify the origin of the goods, the source, where it's coming from, right? So I hope the definition of a trademark is clear. So I'm pretty sure you have heard of trademarks, Google, Nike, even Zoom. So those are all well-known trademarks, right? So now the question is, at what point do you have to think of registering the trademark? When you're starting up a business, it could be any business, partnership, company, or anything. When you're coming up with a product or a service, at that point itself, I think you have to think about registering your trademark. Why? First of all, and registering your trademark in the sense, please note that all marks cannot be registered. Whatever you come up, just because, okay, if you come up with an immoral word, do you think you can register it in Sri Lanka? No, you can't. So at the point of coming up with a mark, a logo or trade, like let's say Google, right? So Google Inc. Or now you call it Google LLC is the name of the company, right? But their trade name is Google. So like that, you come up with a name for the company, but you come up with your trademark as well, right? So once you come up with it, you have to make sure that it is a trademark that is admissible under our law. So for that, what you have to do is you have to go to the IP Act. Section 103 and Section 104 gives out the grounds for objections, right? So Section 103 actually lays down the absolute grounds. For example, if your mark is, let's say, descriptive of the goods and services which concerned, right? Now, in that case, you can't have a mark that describes your good or describes the service that you're providing, right? Now, if you're going to open up a restaurant, right? Then are you going to call it the restaurant, or are you going to call it Food City or something like that? Now that describes your good or the service, right? Here it's the service. So once it describes, you cannot, if it describes, the registrar would not accept it, right? Under absolute grounds, right? So like that, if a mark is immoral, or if he doesn't distinguish your goods and services from those of others. So there are several, if it's a generic term, so there are several other objections like that. So when it comes to relative grounds, actually relative grounds is where you're comparing with other marks which are already in the market, right? So it can be registered marks, and it can be marks that are being applied at the National Intellectual Property Office for registering, applied for registrations, that is pending registrations, and marks that are already in the market out there in Sri Lanka, right? Sometimes they might even consider marks, foreign marks. They might even consider foreign marks, right? So because of that, right, it is essential at the time of actually starting up your business to think of a trademark and then do a proper, thorough search before finalizing your trademark, right? So what I suggest is, before finalizing your trademark, you should always go to the National Intellectual Property Office and do a search there, right? Like now, for trademarks, you have to register it under a particular class. Now, if you're providing a service in the tourism industry, there is a particular class for that, and you're registering your mark in that particular class, right? So when you're doing a search, you go to that class and check if there are identical or similar marks. So relative grounds, where they actually care about, where they compare whether there are they compare with identical or similar marks. So as I told you, I suggest you do a search at the NIPO. Also, you have to do like an online search. It could be just a random Google search. And you can even go to the extent of hiring an investigation team just to see if other people, if other sellers, or if there are other users using the mark that you're intending to have. And also there are international databases like the WIPO trademark database. You can go there. It's all free. You can just go online and check if there are similar or identical marks. Because if there are similar or identical marks, the NIPO, when you apply for registration, the registrar will refuse them or reject them under these grounds, right? So basically with trademarks, what we have, what is expected is to have very unique marks for each seller to have their own unique mark, rather than having very similar or very common marks, right? So for a startup company, even though you are not actually considering registering your trademarks, I think you have to think of protecting or think of registering a trademark, because when you're coming up with some logo or trademark, you have to think of a mark that is admissible under our law. Otherwise, what happens? You start your business grows, and you think you have a trademark, but someone comes and sues you, takes action against you, right? Another person who uses your mark or uses a mark which is similar to yours, and they are going to say, I have registered this mark, you have no right to use it, because the registered owner has exclusive right to use the mark. So others are prohibited from using that mark as a trademark, right? So only the registered owner. So this is why I'm telling you, it is very, very important to think of sort of protecting it and applying it. And the other question that most of us have is that, the registration process takes a long time. It may take up to 5 years to register your trademark. Now people are going to think it's pointless to register. If it's pointless, if it's taking such a long time, because you're not even sure if your business would last for 5 years, right? That is true. But the thing is, when you're applying with trademarks, the important date is actually the date of filing for registration. It is not the date that you're actually receiving. It's not about the date you are actually receiving your certificate of registration. You have to remember that your registration is valid from the date of filing the application, right? So you get priority. So if you have an earlier filing date, it will be beneficial for you. And for you to apply for a trademark, you don't even have to have a proper business, right? You just have to, maybe you have to have a company. If you're going to register it under your under that company's name, or you can even register as an individual, right? So if you are thinking of opening a company, I think it is essential for you to think of the trademark, the trade name or the trademark, because the trade name can be interlinked to the trademark. Sometimes it may not be. Sometimes you might have a big, long company name, but you don't want to invest on that big name. What you do is you create a simple word and you want to invest on that. You make that as your trademark and invest on that. And the other thing is that even when it's a startup, you will have to invest on branding. So you invest so much, maybe after the first year, you promote your name, you spend so much for advertising, you spend so much on branding, but if it's not protected, someone can always register it first and say, I applied for registrations first at least. So you have to stop. Basically, if that person, if the other person who uses a similar mark or an identical mark, if that person applies for registration and if the application gets accepted, that person can always come and sue you. So those are the main benefits. Other than that, of course, if when you register your trademark, you can always conclude license agreements, like you can rent your name, right? And you can charge for it. So that is a cool thing that you can do. So those are all the benefits that you're going to get. And also you can invest so much on your trademark, and you can actually, when you want to close up your business, or even if you're bankrupt, if your trademark is well known, you can sell it for a really, really, really good price, right? Millions, or even billions, right? So it is always a good idea to invest on branding, but if it's not legally protected, you might have a lot of disadvantages. But as I told you, registering a trademark is not compulsory. And for unregistered marks, there is some sort of protection under unfair competition when the marks are not registered, but the marks have to be very well known among the citizens of Sri Lanka. Only if the marks are well known, you will have a benefit. Then only you can say if someone else is using your mark, then you can actually take legal actions. But we are talking about startups here, right? So probably you won't have a well-known mark at this very early stage, right? So your goal should be to apply for registrations as soon as possible. And also when you're trying to register it, I told you, you have to think of, you go to section 103 and 104 of the IP Act and check what are the requirements and what cannot be accepted, right? In that case, if you have satisfied all that, the registrar would not refuse your mark, because there is a procedure. Once the registrar refuses the mark, you can make written submissions, or you can go for a hearing, and then the registrar would re-examine the whole thing and will give the final decision, right? So the registrar would not or most likely not refuse the mark, right, if all those requirements are being fulfilled. If it's not a descriptive, if it's not immoral, and if it's so unique, and if it's not a mark which is similar to other marks, then I have satisfied all my requirements. Even the process will take place sooner than expected. So it might even your mark might get registered within 2 to 3 years. If not, if it gets refused, you have to make submissions. It's a long process. It becomes a long process, right? So my suggestion is, a lot of people are not aware of intellectual property law, and a lot of people, even though they know what trademarks are, they don't know the legal aspect of it. They know when we say a brand, they probably know what it is, but when you say a trademark, it has a legal definition, and you need to know that it can be registered, and in my opinion, it should be registered. Now, copyright, of course, that's part of intellectual property, is you don't have to register copyright, but trademarks, you need to register it, and that registration is valid for 10 years, but you can renew it. So you can keep on renewing it, and you will have the mark for yourself forever, as long as you renew it. So I think it is very important, even for startups, to think about these legal aspects, because it is very, as I told you earlier, when you're coming up with a nice name, an attractive name, you also have to think of the legal aspects of it, whether it is admissible as a trademark under law. So because after that, if you don't consider them, you will have to face legal consequences. I think I've covered the basic aspects. If there are questions, I'm free to answer. I'm happy to answer.
Thank you so much, Miss, for all of that. That was very, very insightful. We will now move on to the Q&A session, but because we have very, very limited time, we can only entertain one question per panelist. Because of that, we will go with the set of questions that we already received. Our first question is actually to Mr. Kahathuduwa. Sir, you mentioned that it's very important that we register our company when you decide that it's no longer a project. But if you look particularly at private limited companies, the process could be quite expensive. So at what point do you think it's important that that they should start a process if they want to register as a private limited company?
All right. So Navira, that all depends on what you're working on, right? There's no generic answer to that question. It will depend on the type of business that you're operating, right? So like what I explained in my earlier session, if you need to get a payment gateway, right, you will have to get it incorporated. There's no other option. I mean, you can't get a payment gateway to your personal name. It will require a BR or a business registration. So in that case, you have to get it incorporated. Then there can be issues like this. Now, there are very famous cases in the world. You can just Google these and see. Ms. Thevuni spoke about the trademarks, and there are the copyrights, and then if you take a step beyond that, there are the patents. So sometimes there have been issues where the patent is under the name of one of the founders in his personal capacity, right? You invent something and the patent is under the name of the founder, but they incorporate a company, right? There are several co-founders. Let's say I am there, Ms. Thevuni is there, Mr. Ashokbharan is there, Ms. Ranindra is there. We incorporate a company and we are running the company, and then we get an offer, right? Let's say we get an offer for 100 million, but the company's worth is actually in the patent because you invented something, but when you applied, you didn't have a company incorporated. So we had an agreement that it's common intellectual property, but to apply it, I applied under my name, under Boopathy Kahathuduwa. So the patent came to me under the name of Boopathy Kahathuduwa. But at an initial stage, when you don't have much revenue coming, these may not be problems. But when you are speaking in millions, these are issues, right? So what is the exact appropriate time to, when you decide, okay, this is the time that I should incorporate? It's a very difficult question to answer in a generic manner. So if you are in doubt, better to get advice, right? That's the best thing to do. If you are in doubt, should I incorporate now or should I not incorporate? Better to get advice from somebody who is competent in corporate law, and they should be able to advise you whether to go ahead with an incorporation, and if so, what type of company that you require or what type of an entity that you require. I think they would be able to answer. Just to add on to that question, Navira, now a lot of startups, they just Google these things and try to find on Facebook. So if you take company incorporation, there are lots of secretarial services which are available, and some services which are available online are actually very cheap. But you should always check. Now, you don't have to be a lawyer to be a company secretary, right? Any person can apply. I think there's a procedure for that. You can become a company secretary. You don't have to necessarily be a lawyer. But when you pick a company secretary to incorporate your company, these are questions that you may have to ask that company secretary, whether that person gives support to you, throughout the company. And there are people who just incorporate the company, gives you the certificate, and then they just wash their hands. But you require, after you incorporate incorporate a company, then you need to submit resolutions, you need to submit returns. So some startup founders get into issues after incorporation. They don't have any help, and they don't know what to do with their company. So these are all things that you need to get proper advice on. So if you are in a doubt whether your entity requires incorporation, better to get advice from somebody who can give you proper advice whether you require incorporation or not. Right.
Thank you so much, sir. Our second question is for Ms. Punchihewa. Ma'am, you mentioned that there are so many types of registrations available, right? But particularly when it comes to the issue of it would depend on the type of company. So what would you suggest, or what would you suggest in the legal field, the type of registration that is most recognized and is most protected by law?
Most protected by law, I'd say, well, all the types of registrations of the company, they are basically gets the same similar protection by the law, but the configuration, whether it's a sole proprietorship, whether it's a partnership, whether it's a limited liability company, whether it's a company limited by guarantee, they all get the same equal protection by the law. But the differences comes up with the agreement or agreement between the people who are involved in the business itself. But if the question is conveyed to me with the idea, I'm just assuming about the amounts that people have to contribute in a situation of liquidation of a company. Of course, the unlimited companies, I'd say, it's most probably similar to sole proprietorships or partnerships. The people will have to contribute to the whole amount of money into the liquidation process, regardless of any limit. But with the limited liability companies, the shareholders will only have to contribute towards the unpaid amounts of shares of their shareholding. So in that sense, it's not actually a legal protection, but I'd rather say it's from the configuration itself of that particular company. Unlimited liabilities, unlimited companies, actually that is in the Companies Act itself, but I overheard from the Deputy Registrar of Companies himself that actually there are no companies registered under that criteria in our company, and it's actually useless provision that has been included in the Companies Act of our country itself. So in terms of protection, I'd say it bears the equal protection, but in times of liquidation, that is the protection. Actually, the investors, the shareholders are the investors of the company. The sole proprietors are is the investor. The partners are the investors. So that is the protection they get in terms of the money they'll have to put in a situation of liquidation crisis. I'd like to add towards the previous question a little bit as well, because the question was when should we decide to start a private limited company. So why actually people are going to start a private limited companies? They are shareholders. Now, according to the new act, we can have one shareholder as well, but in previous days, if there are more than two people, then it was suggested that it is better to have a limited liability company incorporated rather than having a partnership, because of the same issue that I explained earlier, because of the amount of money that they'll have to put in situation of a liquidation crisis or closing down of company. So that is actually one plus point that people have to see, whether to have a partnership or a limited liability company incorporated in terms of the money they'll have to put in a situation of a crisis.
Thank you so much, ma'am.
Yeah.
Our next question is from Mr. Ashokbharan. Sir, you mentioned the process of hiring, but one particular issue with startups are the fact that even the hiring process itself is difficult for them. And then the issue kind of comes up whether, in your opinion, do you think a person who wants to start a business, they should already have a sort of experience being in a working experience so that they know what to look for in a candidate? Or is it okay for them to, in the first get-go, to start a business on their own?
On a practical perspective, I think most of the startups start with a team, and all of them are, if they enter the process of incorporation, in my experience, I've seen all of them remain directors. So they are the ones who own the company. In lay terms, they are the ones who own the company, and they are the ones who work for it. So that is how startups come by before they get into recruitment. At that stage, it is not very complicated because they will have some understanding. But I believe the difficulty starts when some of those founders only maintain a role as a director, whereas some take up an executive role. So when a director takes up an executive role, then he becomes an employee, and that at that point, employment comes into play. But another difficulty, as you say, is recruiting people. You do not know, you don't have experience. You could end up making bad decisions. That is exactly why it is advised, if you do not have expertise or in human resources, that is in recruitment or anything, and if you are not in a position to accommodate a human resources manager or a human resources professional in the recruitment process, it is always advisable that you recruit someone with a fixed term contract, say 1 year or 2 year, that's up to your business decision based on your budgeting, and have a probationary period included. And during that probationary period, give constant feedback. If you are dissatisfied, always give a feedback in writing, and based on that, if you are dissatisfied with the performance, uh, showing your bona fides, you can always terminate uh, the employment during the probationary period, the probationer during the probationary period. And I think that is one of the best things you could do, considering that you are a startup when you get into recruitment.
Thank you so much, sir. Uh, Lastly, Miss Amaradasa, I have a question for you. You mentioned regarding the trademarks, where when you register for a trademark, can we just clarify whether that particular, when you register for a trademark in Sri Lanka, is it applicable? Is it applicable as a trademark throughout the world, or is it only applicable to Sri Lanka? But say if you were a business that did want to establish your trademark internationally, would you have to register from each and every country you do business with? Or is there a particular organization where you could just straight away have you would register the trademark for internationally and have no problem at all? Ma'am, you're muted.
Um, Thank you, Navira, for that question. I think it's a very good question. Yes, you have to register in other countries if you want protection from other jurisdictions, because usually intellectual property law is territorial. So once you register, it only applies in Sri Lanka. If you want protection in other countries, you have to go to their respective countries and register it. Now, when it comes to patents, it's a bit different uh, because of the Paris Agreement, there is a way of registering it in Sri Lanka here first, and then you can apply for like an international registration, but still there is a national phase to it, right? It's just going to make the procedure faster, but still you got to present all your if it's a patent, you have to present that the patent claims all over again and make sure there is no similar invention in those countries as well. So just like that, in trademarks, as of now, you can only, there's a thing called, you can claim priority because as per the WIPO agreement, if you can claim priority in the sense, I told you the filing date is the most important thing. So you can go for an earlier filing date if you have registered your trademark in another country, but if it's under that agreement. But usually when it comes to trademarks, my answer would be you have to go to that respective trademark office or intellectual property office and register it separately. But I think I must add to it, if you have registrations in, now let's say you have registered it in the US and some other countries, but you have not registered it here. In that case, if someone uses that mark here, someone else uses that particular mark, provided it's a well-known mark and it is so well-known in Sri Lanka as well, then they have then they can actually take actions against that the person who uses the mark in Sri Lanka, because it's a well-known mark. As I told you, even if it's unregistered, there is protection under our law, under unfair competition.
Thank you so much, ma'am. Due to the limited time constraints, we have come to the end of our session today. On behalf of all Rotaract clubs, thank you to all of the distinguished panel for being here and for taking the time for almost 2 hours to go through every aspect of to help the aspiring entrepreneurs and aspiring lawyers as well. We would also like to thank Lawtutor.lk for being our knowledge partner today. With that, we come to today's to the end of today's proceedings. Thank you so much for everyone who joined. We are so sorry we couldn't entertain all the questions, but if you all do have any questions that you want to direct to the panelists, do feel free to message them to us and we will forward them on to them. Once again, thank you for joining. Have a great day. Good night.